Right at this very second, you are likely in violation of a federal statute that mandates a 10-year sentence in a federal penitentiary, and you are completely oblivious to the danger. Just last month, federal agents apprehended a gun owner in Texas. His crime? An action he believed was his sovereign right with his own pistol. He is now facing felony indictments that will liquidate his assets and destroy his future. Today, I am exposing 7 fatal regulatory traps set by the Bureau of Alcohol, Tobacco, Firearms and Explosives that can reclassify you as a felon before the sun sets. By the conclusion of this briefing, you will possess the tactical knowledge to navigate this minefield and remain on the correct side of the federal code. We are not discussing minor infractions or administrative slaps on the wrist. We are talking about fines of $250,000, 15 years in federal confinement, and the irrevocable, permanent forfeiture of your Second Amendment rights. The Bureau conducted nearly 10,000 compliance inspections last fiscal year, uncovering violations in nearly 2,000 distinct cases. Many of these targets had zero intent to break the law. Do not become a statistic in their database. Trap number 1. The paperwork perjury pitfall on ATF Form 4473. This is where honest intent meets federal prosecution. Picture this. You enter a firearm retailer to purchase a weapon as a birthday gift for your son. The dealer presents Form 4473. You arrive at question 11. Are you the actual transferee or buyer of the firearm? In your mind, you are buying it for another, so you check no. The transaction is terminated instantly. You have just formally admitted to a straw purchase on a federal document. But here is the deception. If this is a legitimate gift, legal guidance dictates you should have checked yes. The Bureau's syntax entraps thousands of well-meaning citizens annually, and the fallout is catastrophic. Look at question 11b regarding your state of residence. If you have relocated and failed to update your government ID, listing your previous state constitutes a federal felony for making a false statement. Question 11c demands your citizenship status. If you are a permanent resident and omit your alien registration number, that is a prosecutable false statement. Question 21 regarding ethnicity and race. Leaving this blank triggers a mandatory verbal interrogation by the dealer, recorded for the file. Why does this minutia matter? Because the Bureau audits Form 4473s with forensic scrutiny during compliance inspections. A single clerical error exposes you to 15 years in federal prison and financial penalties hitting that $250,000 cap. Last year alone, auditors flagged over 32,000 violations related to improperly executed Form 4473s. Understand the gravity. That is a felony conviction, the stripping of your gun rights, the loss of your voting franchise, and a criminal dossier that shadows you to the grave. Here is the protocol for survival. First, if you are purchasing a firearm as a bona fide gift, meaning entirely your capital, with absolutely no expectation of reimbursement, you are legally the actual buyer. Mark yes on question 11a. Second, never accept currency from a third party to acquire a firearm on their behalf. That is the textbook definition of a straw purchase and a one-way ticket to indictment. Third, analyze every syllable of the form before applying ink. If ambiguity exists, demand clarification from the licensee. Fourth, never falsify data regarding criminal history, substance use, or mental adjudication. The Bureau cross-references your attestation against federal databases. One deviation transforms a lawful purchase into a federal crime, but the paperwork is merely the entry point. The next regulatory snare has converted millions of law-abiding citizens into accidental felons, and the majority are currently unaware of their exposure. Trap number 2. The geometry of entrapment. Possession of a short-barreled rifle or shotgun without NFA registration. You inherit a shotgun from your grandfather, an heirloom held for generations. You transport it to the range, and an observer notes the barrel length appears truncated. You apply a tape measure, 15 inches. Here is the critical methodology for measurement. For rifles, measure from the closed bolt face to the muzzle's end, excluding muzzle devices unless permanently welded. For shotguns, from the closed breech to the muzzle. Total length is critical. Rifles and shotguns must maintain an overall length of at least 26 inches. If you possess a folding stock, measure in the fully extended configuration. Miscalculate by a fraction of an inch, and you are in possession of an illicit NFA item. Under federal statute, any shotgun with a barrel under 18 inches or rifle under 16 inches is designated an NFA firearm. If this hardware is not registered in the National Firearms Registration and Transfer Record, and you lack the tax stamp, you are holding contraband. You did not modify it. You did not know. But in federal court, ignorance is not a defense. It is an admission of guilt. The penalty for unregistered NFA possession is 10 years in federal prison and fines scaling to $250,000. The Bureau will execute a permanent forfeiture of your entire collection, not merely the offending item. Your right to bear arms is extinguished. Your criminal record will incinerate your employment viability, housing applications, and civic participation. Here is your defensive strategy. First, audit every barrel in your inventory immediately. Rifles, 16 inches minimum. Shotguns, 18 inches minimum. Second, upon inheritance or acquisition, verify barrel length instantly. Third, if you identify an unregistered NFA item, secure counsel specializing in firearms defense immediately. Do not transport it. Do not attempt to surrender it to a dealer. Fourth, if you desire to legally possess a short-barreled configuration, file ATF Form 1, remit the tax payment, which is scheduled to drop to $0 starting January 2026, and wait for the physical stamp before altering any hardware. The silver lining. The NFA tax is slated for elimination in 2026, but the registration mandate and the draconian criminal penalties remain fully operational. Next, now, we approach the sector of maximum volatility. The Bureau has reversed its position on a regulation impacting tens of millions, creating a fog of war where confusion leads directly to federal court. Trap number 3. The pistol brace bait and switch. This is the single most controversial regulatory pivot in modern history. For over a decade, the Bureau issued guidance stating pistol stabilizing braces were lawful accessories. Millions of citizens purchased them in good faith. Then, in 2023, the Bureau executed a 180-degree turn, declaring that pistols equipped with these braces are now short-barreled rifles subject to the National Firearms Act. Overnight, millions of legal owners were reclassified as felons, while federal courts in Texas and the Eighth Circuit have vacated this rule, labeling it arbitrary and capricious. Do not be lulled into a false sense of security. The Bureau is still engaging in enforcement actions. Gun owners are trapped in a legal no-man's land. You may believe you are shielded by a judicial opinion, but the Department of Justice is still filing indictments. Consider the case of Taylor Taranto, charged with illegal possession of a short-barreled rifle for owning a CZ Scorpion pistol equipped with an SB tactical brace. The prosecution utilized criteria from the very rule that was invalidated, pistol weight, surface area, length of pull, to categorize his lawful pistol as NFA contraband. The Bureau's criteria were subjective traps. Does the brace have surface area consistent with shouldering? Is the weapon too heavy for single-handed fire? Does the length of pull mimic a rifle stock? They even scrutinized marketing materials to see if the brace was demonstrated being shouldered. The courts declared these metrics arbitrary. Essentially, the Bureau was fabricating law on the fly. Yet, while the judiciary debates, citizens are being handcuffed. The danger lies in the legal uncertainty. This individual is staring down 10 years in federal prison and a $250,000 fine for possessing an item the government previously explicitly permitted. Here is your protection protocol. First, if you possess a braced pistol, consult a firearms attorney in your specific jurisdiction to assess your immediate exposure. Second, consider detaching the brace entirely and storing it in a separate location. Without the brace attached, the weapon is undeniably a pistol. Third, if you insist on retaining the brace, you may register the firearm as a short-barreled rifle under the NFA. Note that the amnesty window has closed. Fourth, maintain constant vigilance on circuit court rulings. This litigation is fluid, and the regulatory landscape could shift again. Fifth, never assume the Bureau's prior guidance offers immunity. They have demonstrated a capacity to reverse enforcement policy without warning. That covers 3 traps. We have 4 remaining. This next violation is the most frequent cause of arrest I witness, committed daily by gun owners who are oblivious to the crime. Trap number 4, the interstate trafficking trap. You are attending a gun show in Pennsylvania. A buyer from New Jersey approaches, offering cash for your handgun. You execute the transaction, shake hands, and depart. You have just committed a federal felony. Federal law strictly prohibits direct sales or transfers of firearms to unlicensed individuals residing in a different state. Every interstate transfer must be processed through a licensed dealer in both jurisdictions. The dealer is mandated to run the background check and archive the records. Even if the buyer holds a valid carry permit in their home state, the private sale is illegal without FFL intervention. Here is the common setup. You are at a show. An out-of-state buyer wants your rifle. Cash offer. You assume because it is a long gun, the rules are relaxed. Incorrect. While federal statutes permit some interstate long gun transfers, the laws of both states must authorize it, and it must still flow through an FFL. Many states mandate that all transfers, handguns and long guns, proceed through dealers. Do not gamble. Always utilize an FFL for any transaction crossing state lines. The penalty for illicit interstate trafficking is up to 10 years in federal prison and fines up to $250,000. In fiscal year 2024, the Bureau executed nearly 10,000 compliance inspections and revoked 195 licenses for violations. Real-world consequences. Shaneen Allen, a single mother with a valid Pennsylvania permit, was arrested in New Jersey simply for possessing her legally owned firearm. She faced felony charges and prison time before dismissal. Here is the lawful methodology. First, if selling to an out-of-state resident, the transfer must go through a licensed dealer. 0 exceptions. Second, ship the firearm to an FFL in the buyer's state. Let the dealer assume the liability for the background check. Third, handguns must be shipped to a dealer in the buyer's state. Long guns can be transferred in person or through a dealer, provided all state and federal statutes are satisfied. Fourth, never hand a firearm directly to an out-of-state resident, even at a gun show. Always utilize the FFL shield. Now, we face a rule that many are unaware of, a permanent ban that offers no retreat. Trap number 5. The Domestic Violence Disarmament Protocol. 20 years ago, a domestic argument resulted in a police visit. You were charged with misdemeanor domestic violence, perhaps a shove, perhaps no physical contact occurred. You paid a nominal fine and moved on. Today, you attempt to purchase a firearm. Form 4473, Question 11I asks if you have ever been convicted of a misdemeanor crime of domestic violence. You answer truthfully, yes. The sale is denied. Under federal statute, any domestic violence misdemeanor conviction, regardless of severity or elapsed time, triggers a lifetime prohibition on firearm possession. This is not a suspension, it is a permanent revocation. Unlike felonies, which may offer paths to expungement or pardons depending on the jurisdiction, federal law provides almost no relief mechanism for domestic violence misdemeanors. Even if your state expunges the record, federal law may still enforce the ban. Even a gubernatorial pardon is insufficient, unless it explicitly restores gun rights. This is why domestic violence charges are a lethal threat to gun owners. If you are discovered in possession of a firearm following such a conviction, you face 10 years in federal prison and fines of $250,000. You forfeit your Second Amendment rights for eternity based on a misdemeanor from decades past. Essential knowledge. First, if you have any conviction for domestic violence, even a misdemeanor, you are a prohibited person federally. Period. Second, audit your criminal history before attempting a purchase. Many are blindsided by decades-old misdemeanors. Third, if facing charges, understand that a plea deal to a misdemeanor is a self-imposed lifetime gun ban. Consult a defense attorney immediately. Fourth, if you are prohibited, do not possess. There is no restoration path. Fifth, if you reside with a prohibited person, secure your arsenal. Constructive possession, where the prohibited individual has access, can result in federal indictments for both parties. Next, that covers 5 Bureau rules capable of dismantling your life. But this next trap is currently blindsiding gun owners, involving a practice you likely consider routine. Trap number 6. The ghost gun reclassification, building firearms from 80% lowers. You purchase an 80% lower receiver online. For years, the Bureau classified these as inert metal, not firearms. You could complete them at home. No serial number, no government tracking. Then, in 2022, the regulatory landscape shifted. Under the final rule on firearms with readily converted receivers, 80% lowers and unfinished frames are now legally defined as firearms. Sellers are mandated to serialize them, execute background checks, and retain records. If you fabricated weapons prior to the rule change, you are now required to serialize them within strict windows if you intend to transfer them. If caught with an unserialized firearm constructed after the rule took effect, the Bureau categorizes you as an unlicensed manufacturer. The penalty for manufacturing firearms without a license is 10 years in federal prison and fines hitting $250,000. The Bureau is aggressively targeting home builders. In 2023, they seized over 25,000 privately made firearms in criminal probes, a massive spike from 2017. Case in point, a California man sentenced to 5 years in federal prison for manufacturing and selling unserialized AR-15s. He believed he was exercising his rights. The Bureau labeled him an illegal arms factory. The agency is deploying advanced surveillance to track these so-called ghost guns. When an unserialized weapon is recovered at a crime scene, they reverse engineer the supply chain through online purchase logs, credit card data, and shipping manifests. In 2024, they inaugurated a specific intelligence unit to investigate privately made firearms. They are subpoenaing vendor records and building dossiers on builders who believed they were operating in the clear. Even if you built these years ago, the Bureau can pursue you today. Here is the compliance strategy. First, if you constructed firearms from 80% lowers before August 2022, serialization is not mandatory for possession, but you absolutely cannot sell or transfer them without adding a serial number through an FFL. Second, if you are building now, the receiver must be acquired through an FFL with a background check. Third, never build with the intent to sell. That constitutes manufacturing, requiring a federal firearms license. Fourth, if the legal status of your home build is ambiguous, consult a firearms attorney before transporting it to a public range. Fifth, archive all documentation establishing the acquisition dates of your parts. Dates are critical defenses in determining which regulatory regime applies. One final trap remains, and this is the one placing handcuffs on gun owners at routine traffic stops across the nation. Trap number 7. The jurisdictional minefield, crossing state lines. You reside in Virginia. Valid concealed carry permit. You are driving to visit family in New Jersey, Glock 19, and 2 17-round magazines secured in the trunk. You are stopped for speeding. The officer inquires about weapons. You are honest. You declare the firearm. You are arrested instantly. In New Jersey, your Virginia permit is void. Those 17-round magazines? Felonies. New Jersey enforces a 10-round cap. Your hollow point defensive ammunition? Also illegal. You assumed protection under the Firearm Owners Protection Act, FOPE, but you stopped for gas. That stop voided your federal protection. New Jersey's statutes carry mandatory minimum sentences, 3 to 5 years in state prison, no parole eligibility. Remember the names: Shaneen Allen, Brian Aitken, sentenced to 7 years for transporting his own guns during a move. These were law-abiding citizens who were ignorant of the jurisdictional trap. State prosecutors are indifferent to your home state's laws. Specifics matter. In New York, possessing an unregistered handgun is a felony, regardless of your home state registration. California prohibits magazines over 10 rounds and recognizes 0 out-of-state permits. Hawaii mandates registration within 3 days of arrival. Massachusetts requires a license even to possess a handgun in a hotel room. Illinois demands a FOID card. These are state statutes that can land you in state prison where FOPA provides no shield. Here is the travel protocol. First, before crossing any state line, conduct reconnaissance on the destination's laws. Magazine limits, ammo restrictions, reciprocity. Second, utilize FOPA strictly. Firearms unloaded, locked in a container separate from ammunition, and make 0 stops except for dire emergencies. Third, never carry into non-reciprocal states. Leave it at home or ship to an FFL. Fourth, download a reciprocity map application. Fifth, if flying, adhere to TSA and airline regulations with absolute precision. Declare, lock, and verify destination legality. These are the 7 Bureau traps that can convert you into a felon overnight. Let's execute a final briefing on the risks. Number 1. Form 4473 perjury, 15 years, $250K. Number 2. Unregistered NFA items, 10 years, permanent forfeiture. Number 3. Pistol brace entrapment, felony charges in a legal gray zone. Number 4. Interstate trafficking, 10 years for a private sale. Number 5. Domestic violence ban, permanent disarmament. Number 6. Unlicensed manufacturing of ghost guns, 5 to 10 years. Number 7. Jurisdictional travel violations, mandatory state prison sentences. Any single error here costs you your freedom, your finances, and your rights. The prosecutor does not accept ignorance as a plea. One misstep, and your life as a gun owner is extinguished. Do not let regulatory confusion destroy you. Subscribe to Guns Law Guide immediately to ensure you never miss an intelligence update that keeps you free. I deconstruct federal and state weapons codes weekly so you can carry with absolute immunity. Strike that subscribe button now. Your liberty depends on your intelligence. Next week, I am exposing the 5 concealed carry errors that are getting gun owners sued for millions, even during righteous self-defense. You cannot afford to miss it. Yan.